All right, good afternoon, everyone, and welcome to today's panel, which is on considerations for senior clients. I want to begin by apologizing with the setup because my back is going to be to you, so please, if you need to move over to see the panel, don't hesitate. My name is Michelle Jacko, and I'm the managing partner of Jacko Law Group and CEO of Core Compliance, and we have a very dynamic panel on what we consider to be an incredibly time-sensitive and sensitive issue, one that I think has touched us not only from our client-based perspective, but even in our personal lives. And, you know, we're very fortunate today to have some of the leading experts in the industry speak to us about this issue. To my immediate right, to your left, I think, right? This is Ron Long, and he's with Wells Fargo. And next to him is Carrie Zinn she's a partner of Bressler Amory. And next to her is Mavis Kelly from the U.S. Securities and Exchange Commission. What we plan on doing is we're going to begin today's presentation with insights from Mavis about what the SEC is looking at, and she's going to lead us through the journey of different considerations for you to take back to your firm. Then we're going to turn the floor over to Carrie, and she's really going to be focusing on all the different regulations that you need to be aware of that are going to be impacting you and your firms. And then, you know, one of my favorite parts of the presentation is really Ron, who's going to walk us through how he has been able to build his compliance program, focusing on senior issues. And then I'm going to bring it all home, and we're going to go through an interactive case study. So I'm going to need you to pay attention. And yes, not just because you're in the front row, it might be the back row. We'll be asking you to do some issue spotting and analysis to really see, you know, these are real life scenarios that we've tried to put together in one case example to see how would you deal with these various issues. And if you were in the middle of an SEC examination when this came to the surface of the CCO's desk, how would you really approach this? Okay? So without further ado, Mavis, I apologize. We now also want to make you aware there are several supplemental materials that are provided in your materials within the app, and a couple that weren't listed. Carrie was very wonderful and provided us with this red flags list for senior exploitation. So that is a must read. There also is a sample SAFE Act policy and procedures template. So when you always go back to your firms, you say, boy, I wish I had a template for this. The Senior SAFE Act policy template is in your materials, okay? We also have a copy of the Senior SAFE Act. I did an article on challenges that you should consider for servicing aging clients. And then the IAA itself has an agreement. And for those of you that may have seen this presentation last year, I want to let you know the template has not changed, okay? But I still think that that's a worthwhile read to just make sure as you're comparing your advisory agreements with the template, have we really considered all the issues with regards to servicing senior clients? So with that, Mavis, she's going to walk us through a variety of different issues, and very much looking forward to your presentation.
Oh, thank you. Yes, it's on. Okay, so hi, I'm Mavis Kelly with the SEC. I also have to give our standard disclaimer. The views I express here today are my own and do not necessarily reflect those of the Commission, the Commissioners, or my colleagues on the staff. So a couple of things I was asked to talk about is our Retire initiative, and that initiative began in fiscal year 2015. It's not isolated to seniors. It was anyone saving for retirement. You know, I was explaining it to my co-panelists that I read somebody in the industry wrote it. It's like eating an ice cream from the bottom up versus top down. We looked at the same issues. Either way, it was all gone. We looked at all these issues. So we looked at marketing and portfolio management and portfolio trading, but some of the issues that really came to the surface early on with that were the share class issues and some other fee-related issues. And you've seen some of the outcome from that most recently with the STSD initiative results, cases that were brought, as well as I think there was a case in November about fee billing practices, retirement
Capital strategies.
Strategies, thank you, in November. So those are some examples of what came out of the Retire initiative. But there have been several other tangential things that we've looked at that affect seniors. I know that the investor advocate, the SEC's investor advocate, in their December state of what they've looked at, mentioned that there's a lot of broker-dealers that migrate, that have disciplinary histories, and through the migration process, a lot of times they focus on seniors because seniors tend to not have financial sophistication. And we did a parallel review looking at supervision practices of advisors that have that employ or hire individuals that have disciplinary histories. We did see that while we didn't focus on seniors in that regard as well, in that initiative as well, we did see that there was there was a lot of non-disclosure of disciplinary events, both at the firm level as well as individual firms, or individual reps, supervision practices that were concerning, and especially when the reps were operating out of branch offices. Sometimes those branch offices weren't reviewed at all as part of the supervision oversight process of the firm. So those are some sort of tangential things that we've looked at. But we most recently in FY17, and it kind of ended in our fiscal year 18, we did focus on seniors, and we looked at, we had our own definition of seniors, which is not consistent with some of the other things that we're going to talk about today. We said 62. That's when people first started get Social Security, so that was our rationale for selecting 62. But we looked at firms' practices with respect to managing, especially if the firm had a lot of seniors, either by assets or by number of clients. We were looking at their practices for beneficiaries. Do they have specific policies or practices for people at or near retirement? Do they do things differently when there's concern for diminished capacity? Is there a process in place? And so I'll go over some of that now. So for roughly a 6-month period, that ended in the first quarter of 2019, we examined over 200 advisors that most of them had 50% plus of their client base, either by assets or by clients that were 62 or older. A third of these firms had policies and procedures that addressed specifically what to do if the client is retired. We noted some issues with some of those policies not being specific enough or tailored. Half of the firms had policies and procedures with respect to diminished capacity. We did notice some issues with that, and one of the issues is not providing sufficient information for the employee of the advisor to identify individuals with diminished capacity, or that may be the subject of financial abuse. And I know that there's some concern, Ron.
She's looking at me because I was very concerned when Mavis brought that up as a broad SEC concern. Medical professionals have a tough time diagnosing people who have diminished capacity, dementia. So to have a Series 60, folks with a license to think they can do more than gerontologists and geriatrics, I think is asking too much. But a firm should be able, and we have some, I think there, in some of the materials Michelle mentioned, there are some basic red flags, but I can tell you right now, I can't remember which pocket my keys are in. That shouldn't be enough to say that you, evil advisor, you didn't figure out that Ron has diminished capacity because maybe it's my normal day. So I do think, and this is all to say we need to work with the SEC, with the examiners, with the firms. There's a place in the middle. We should know a little bit more, but we're not Johns Hopkins medical professionals.
But I also want to add in, and I think, just to kind of think about this, by a show of hands, how many of you actually have identified a person within the organization to escalate an issue to if they detect diminished capacity? Any? Okay, did you folks go through special training, or did they have adult protective services? So, I think one of the things that the commission's also looking at is what's the training program for that individual, and how have they educated themselves? Have they educated the advisors?
Right, and even if you have a concern, but it's not something you can put your finger on, whether or not you've put in the account on some sort of heightened supervision. So it's not that you can check the box of all the things that, yep, there's diminished capacity. Have you then done anything to address that concern in some way? Okay. And is that part of your policy? So, some of the other things with diminished capacity, there's a lot of talk about, do you have a trusted person? And so some advisors had built that into their policies and procedures for if there's a concern for diminished capacity, you can go to this trusted person. But then they didn't have the trusted person a required field to be answered. And so if you then needed to trigger this, you had no contact. So there was a disconnect between the policies and the practices of the firm. So there's some other issues that we've found. And then, so flagging the record keeping system or some other way, to mark this account as a special account that requires, some of the firms didn't have this sort of feature other than, well, it's in our file that we're concerned, but how does that work out in practice? How are you going to really know that this account requires special scrutiny?
One more point of order. But remember, for IAs, trusted contact is not an official requirement. So now...
Right, but if it's part of your policies...
That's what I was going to say.
Yeah.
You just possibly convinced the audience not to put it in their policies.
No, I wouldn't say that. I would think that perhaps the policy should be modified to read, we will make a best efforts to see whether or not the client would like to provide us with trusted contact information because of the following reasons.
Right, and some of the feedback I think the staff had heard is, well, that's an awkward conversation. But I was actually recently reading an article where it's saying, well, you shouldn't wait until it becomes an awkward conversation. That should be, hey, this is our standard policy. We're asking this of our 20-year-olds and our 70-year-olds. Can you give me a trusted person? What happens if you fall and hit your head? There's if you're going to make it a practice and it's a wise practice in circumstances, then just find a way to make it part of your program. Yes.
I think one of the things I would just mention is we have to be careful to not consider that trusted person someone as strong as a power of attorney that has the right to take action on movement of money.
That's right.
And the other thing I would say about trusted person is even the custodians are getting smarter in that area. Someone like Schwab now has a document that you could actually notate that you want to designate a trusted person.
Can everybody hear that? Okay.
Yeah, and don't let it be said that I'm saying you shouldn't have trusted contacts. But I do want to make sure, again, it's working together as a working to gotcha. So if there is a trusted contact person and you think you want to do that, Mavis is right, let's have some policies, but let's not go around spanking people because they haven't crossed every T and dotted it.
Ma'am, I'll get to you in 1 second. I do want to state, though, that awkward conversation. Before this presentation, I pulled out, this is from the SEC. This is part of their investor advocate, okay, or investor bulletin, and it was help for adult protective services workers encountering senior investor fraud. And the last bullet point talks about the importance of notifying the financial institution so that they could reach out to trusted contacts. So it kind of goes full circle. And if you think about it, we're trying to do this to be informed and to help, not to have that awkward conversation that is just part of life. Yes, ma'am.
Custodians are collecting that information now on a lot of their new paperwork. Do we rely on custodians' paperwork?
I think if you put in your policies that we will rely on the custodians, trusted, then you've kind of run full circle. But I would, if you're going to say that and the custodian doesn't require that, then I don't know that you fulfill, I don't know if all your clients use the same custodian and, all those sorts
We're
of
going
things.
to touch upon that, I promise, before the end of this session. Okay, and it'll come up in the form of the case study and things like that. So we will be circling back, and we'll make sure that we address that.
Yeah. And I also want to say that a lot of what we looked at was so written policies and procedures as well as practices, because this is kind of an evolving area of policies and procedures. And so some of the things we observed was not written, but it was a practice of the firm regardless. So also we were looking at if if advisors had policies, procedures, or practices with respect to elderly or senior clients, and you know, half of the firms or so did have these in place. However, they weren't really tailored for the firm, and a lot of advisors that have a broker-dealer affiliate, they kind of just adopted their broker-dealer's policies, including the name of the broker-dealer affiliate. So again, just, you know, think about what is applicable for you and your practices and modify it. Or they delegate it to a third party, such as the custodian, to perform certain tasks, but it's not memorialized or part of the policies. Or they adopted a seniors policy and said seniors, and everybody knows what that definition is, but you should probably make it a little bit clear, because we have 62 and other policies have 65, and what happens if they're not 62 or 65, but they're retired, or what happens, you know, so you should just define what you mean by seniors. So those are some of the issues we found in that, that area. And then we also looked at beneficiaries and requests to change beneficiaries. Some of the interesting things are, you know, advisors might have required notarized consent of the spouse, the client's spouse, but the spouse is not named on the account or a part of the account. I know some retirement accounts require that as part of the contract, but there was no reason why the spouse had to sign to have the client. That was a little
Getting more
odd,
complicated,
but it was
yep.
found a couple times. And limiting the applicability of the beneficiary change processes to specific accounts or products or services, you know, like for insurance products or IRAs only. But, you know, if you have a change in beneficiary for a joint account or for individual brokerage account, I don't know why you shouldn't consider that as well. And not specifying what red flags mean and how they'll be monitored. So those are some of the issues with the seniors that we found. Let's see. And not specifying how changes to accounts will receive supervisory approval, other than, you know, saying, hey, this is going to require approval from whom, right? How is it documented? Those sorts of things. Let's see. And we also looked at how to contact the trusted point of contact if there's concerns for diminished capacity. And, you know, not that there's anything wrong with consulting an attorney. That's a great idea, but that's what the procedures would say, is consult an attorney. And, you know, this for the employee of the advisor, is it do I seek an outside attorney? Do I look for somebody with specialty in diminished capacity? And so, you know, it should be a little bit more specific. Contact, you know, compliance, CCO, contact, you know, so a little bit more specific in that regard. And surprisingly, there was a small percentage, only 25% of the advisors or so, presented trainings to their employees on the policies and procedures, even though a lot of these firms, you know, most of these areas, over 50% of the advisors we examined had policies in these areas. They didn't train their employees on them.
That's probably the most surprising of the findings.
Yes. Yes,
Okay.
and so that's our senior initiative, and those are kind of our high-level observations.
Fantastic. Now, I want to let you know, in the interest of time, okay, because this is going to be a beautiful segue, I'm going to turn the floor over to Carrie. But before we do so, I'll limit it to 2 questions. Are there any direct questions for Mavis? We will have time for Q&A at the end. Anybody? Is that why you
Raise
sat
hand
there?
Thought you didn't want to be called on.
So, am I getting this right? There are no rules for advisors specific to seniors, but there's an expectation that you may have upon an examination?
So what we were concentrating on was advisors, that is a significant part of their business. And as a fiduciary, you know, you should look at your client base and think of some of the issues that are applicable to them. So there's nothing in the Advisors Act specifically that says you need to have these sorts of policies and procedures in place, and it's not one of the core areas listed in the compliance rule. But if it's a significant part of your business, your clients, or even if it's not, you know, there are certain risks and concerns as a fiduciary for overseeing and providing portfolio management services applicable to that client. And if you're asking them, you know, for consent in executing a portfolio strategy, and this person can't understand what you're asking them to do, how is that fitting in with your fiduciary obligations? So
Yeah, and what I've seen, and I'm sure Carrie, you've seen this in
she's itching
exams.
to
She's
talk
like,
about
that compliance program rule has a wonderful footnote that basically says you have to customize your policies and procedures to your business. And I've seen lots of deficiencies written up in a 206-247 violation.
Yeah, and look, the bottom line is this is going to be the crime of the 21st century. So if you haven't encountered it yet, you will. And the SEC is very concerned about senior issues. And fortunately, there are some good regulations that have been passed which can help you with regard to reporting it. I'm actually a big fan of the trusted contact, not saying you aren't, Ron, because I'll just add that, because it's better to call the trusted contact and deal with them than if you call APS and have to deal with them. Your client's going to be happier if you spoke to their family member or somebody else versus them getting a call from the state saying, we heard that you're, lack capacity or you have diminished capacity.
I'm going to interrupt 1 second, though, because, and it's not a Mavis problem, but having heard what she just said, the SEC should then come out with some nice guidance. You don't even have to call it a rule, just
You
guidance.
can talk to IM.
I know you were
We'll
going
be
to say
calling
that,
them after
I'm in
this.
inspections.
but it shouldn't be incumbent upon an advisor to happen to be at a conference where Mavis happens to speak and then happens to say, oh, we think this is a full expectation of what you should be doing, which don't get me wrong, I agree with it. I'm the elder guy for Wells Fargo because I'm the oldest, but that is what we want to do. I think you should help and say, this is what we think you should be doing, bullet by bullet.
I think Carrie's going to talk about some of the other guidance that is out there,
There's
not from the SEC, but from others.
That's fair.
One of the things that I always look at, to determine, how the SEC views something, because oftentimes there isn't a black and white reg on every topic, is what are they saying about it? What is the commission saying about it? And we have a slide up in which Chairman Clayton in 2018 basically said in very strong words that he despises the behavior when somebody financially exploits an elder person. That should be a flag to you right there, that the commission's going to be focused on it. And then they issued a paper, actually, which is a really good read, and I highly recommend it. The Office of the Investor Advocate in June 2018 issued a paper. And in that paper, they basically say that investment advisors are uniquely positioned in order to be able to identify financial exploitation. So really, you have to kind of read between the lines, piece together what the commission's saying, look at what they've written white papers on, and that will show you, how much of a priority it is for them. And, as a regulatory lawyer, I can tell you that this is one of the biggest risk issues for firms and is going to continue to be for the next decade. There was a recent CFPB report in which they analyzed SARS during a roughly 3-year period, and they found, based on the analysis of broker-dealers and others reporting financial exploitation of elders, they actually found that it tripled within the 3-year period the number of reports. And so this is really going to just continue to exponentially grow. If you haven't encountered this issue yet, you will. We do have some good news, which is there is a new regulation out there, the Seniors Safe Act, which came out in 2018, and it encourages financial institutions and others, and investment advisors, of course, to report financial exploitation of somebody 65 or older. You have to meet the requirements of the statute. If you meet the requirements of the statute, then you will have immunity. Not only the actual IA firm will have immunity, but individual employees will have immunity as well if you apply the statute correctly. So what,
There's your incentive.
yeah.
Well, remember, immunity does not mean you will not be sued. It just means you have a better chance of winning. So just to be clear.
But I do have a technical question. I'm sorry to go off in a segue. Does this also mean, and I want to clarify this for everyone, even though you're immune, that does not mean that the staff will not come in to investigate as to whether or not you've complied with policies and procedures, correct?
Oh, that's correct.
Yeah, that's definitely correct. So what is the Senior Safe Act? What are the requirements? Well, obviously, you need to be reporting it in good faith and with reasonable care. So you're going to want to keep your reporting narrow to the specific exploitation that you saw and not really disclose every single thing about the client. Just report narrowly on, the activity that's of concern. The report has to be made to what the statute calls a covered agency. What's a covered agency? A covered agency is one of the alphabet soup of government agencies that touch on the financial industry. SEC is one of them, of course. Whole host of other ones, banking ones that aren't applicable here. You can actually also contact law enforcement as a covered agency or adult protective services at the state level. That's who you have to report it to in order to be able to hopefully be cloaked in the immunity under the statute. There's, the key requirement, though, is that you have to receive training. So those of you who are going to follow and apply this act need to have a training program in place to ensure that your staff, your employees, are receiving the training required under the statute so that you can invoke the immunity. What is the training? There's specific things that you need to do and include in the training. It's the obvious things, right? It's how do you identify financial exploitation. There's red flags. I always recommend that you put the red flags in your policy and train employees on it so they know what to look for. And they need to know how to report it. As Michelle asked earlier, if any firms have designated, a person to whom things should be escalated, I think that is the best approach. You should not put it on individual employees to have to reach out to, a regulator or law enforcement or an agency. There should be somebody it's escalated to, either a compliance person or if your firm's large enough, in-house counsel, and then that person can assist. One of the key things to train on also is obviously you're dealing with a very sensitive topic and people's information. So the training has to relate to making sure, that you're respecting the privacy and the integrity of the client. That's an important fact. And the training must also be appropriate for the job responsibility. Now, the Senior Safe Act doesn't specify how often you have to do the training, but I can tell you as a best practice, I'm sure Mavis will agree, annually is best, and when you have new joiners, doing it as soon as, reasonably practical is a good approach as well. That way, when the exam staff come in and they say, what are you doing? When did you train people? You can say, oh, we just trained them this year or last year. You don't look so good to a regulator when you say, oh, we trained 5 years ago on this, because, you may have new people, there may be new red flags, new things you need to look for and so forth.
Carrie, we had a question come in, and I think it's a good one, and I've heard this before. Are you aware, and I'll open this up to the panel, are you aware of any training modules that folks can go to satisfy this training element requirement?
So there's a host of different companies out there right now who are putting together training modules. And if you look online, you can generally find them. Some of them are free. Some of them you have to pay for. There's other people like, for example, I go out and do the training and give training to, my clients. And there's consultants who do that as well. So there's a whole wealth of resources out there for you, to be able to obtain the training. And, in my view, if you go and you do a module online by a professional company, that's fine, so long as it covers, the requirements, which if it says Senior Safe Act training, it will, cover the requirements. And the SEC doesn't have an issue with that.
So long as you conduct due
As long as
diligence,
it's tailored
right?
for your business.
As long as it's tailored for your business. Or you can, get your outside counsel to come in or a consultant, and they can take you through the training. So there's lots of resources.
You need to keep an eye on your various state regulators as well. They've gone around, and I know Delaware went to a number of cities within, you don't have to go far in Delaware. But anyway, there are a number of states that go around and will offer training sessions. I'm sure that's perfectly fine as well.
Yeah, so the Senior Safe Act is the federal law, right? And so that'll give you immunity if you follow it and, strictly adhere to the terms and have the training. The other thing you need to be concerned about, of course, is state law. There's two types of state laws, two categories, I like to call them, across various states. I call one category report and hold. Report and hold is very similar to a NASA Model Act that was put out, and it generally imposes reporting obligations on broker-dealers and state-registered investment advisors. There are a limited number of report and hold laws that are worded broadly enough that they could be read as applying to SEC-registered investment advisors. Some states specifically carve out IAs. Some states, it's clear from the language it doesn't apply. And then there's these handful of states, which I'll talk about in a moment, which you really need to be concerned about on the report and hold. Other than the report and hold, there's the adult protective services exploitation laws. Those tend to be incredibly broad and basically tend to say, anyone must report financial exploitation. So I would have to report it. The guy next door would have to report it. Anyone who observes it has to report it under those types of laws. And those really broad protective services laws, they can sometimes have criminal penalties for not reporting it. So it's pretty important, that people comply with those as well. But I'm going to talk about report and hold state laws for a moment. So report and hold is what I indicated, usually applies to broker-dealers and, state registered. But there's 21 states with report and hold laws. 6 out of the 21 are what you need to be concerned about, because 6 out of the 21 on their face can be read as applying to SEC-registered investment advisors.
And I just want a moment. On your app, you will have a copy of this PowerPoint presentation. So I know a lot of you are taking furious notes. I just want to make sure everyone did that.
And the states, you can see them up there: Alabama, Arkansas, Louisiana, Texas, Tennessee, and Washington. They have varying degrees of reportability. Some are should, some are mandatory, and some are permit. But, if you have a customer that's being exploited in one of those states, you should really take a close look at those state laws, report and hold laws, because they are broad enough to be read to apply to you as an SEC-registered IA. So, Adult Protective Services state laws, APS is what we call them for short. Again, these are the ones that, in particular, are broadly worded, often have civil or criminal penalties if you do not report the exploitation as required. And we've listed the slides, and in this slide, the states that have those laws. In addition, and the other thing to be concerned about is with regard to these state laws, which can be read broad enough, like the report and hold laws, et cetera, that can be read broad enough to apply to registered investment advisors, is you should be concerned about which ones require training. Because just like under the Federal Senior Safe Act, some of the state laws require that you hold training on elder exploitation and how to spot it and report it. In particular, you should be concerned about Washington State. As you can see in the slide, Washington State has actually, their regulation, it's unlawful to provide investment advice to clients unless the firm provides training. Failing to provide financial exploitation training is considered an unethical business practice. So they're probably the strictest ones when it comes to the training. So really, if you have clients in Washington State, make sure you're doing the training just to mitigate the risk. Connecticut, Nevada, Puerto Rico also have training requirements. And, you got to be really careful. We've got 50 states. The states' laws vary, of course. Some have report and hold, some have APS laws, some have both. So it's important to make sure you're reporting under both laws if it's a state that has both. In some instances, it's mandatory to report, other times it's permissive. The definition of senior can change. So for the purposes of the federal law, it's 65. But there are other states which bring it down to 62. So that's important to keep in mind as well. And it varies who you have to report it to. Some states it's Adult Protective Services, some states it's other agencies. And so it's really nuanced. And just keep in mind, by the way, if you do report it under the Senior Safe Act and say you report it to the SEC as your primary regulator, that does not relieve you of any state reporting obligations. So you need to make sure that you've reported it to your regulator, great, but do you have any obligation to report it to any state regulators? Given the variation in state law, if you see financial exploitation, escalate it to the person at your firm who's responsible for handling that. If you're a smaller IA with a single compliance person who's unsure, your best bet is generally then to go to, an outside counsel and seek their advice. Because the last thing you want to do is not report something, turn out that the person was being incredibly financially exploited. The SEC will come in and look at it, and then you could be facing, fines by the state level as well. So it's pretty important. But I do have good news for you as to how you can figure this out.
Which I endorse, just so you know.
So I'm with the law firm Bressler, Amory & Ross, as she indicated, and we represent financial institutions, investment advisors, broker-dealers, the entire financial services industry. And we are incredibly concerned about the risk that all of the various industries face with regard to financial exploitation. The boomers are starting to age. This problem is not going away. So we formed a seniors issues group. And one of the first things we did was we prepared a 50-state map survey. And basically, if you go to our website, or it's on the IA, it's on the Investment Advisors Association website too, you can link to it from there. You'll see this handy-dandy map, and you just click on a particular state, and it will pull up a summary of, it'll say whether or not the state has a report and hold law, and who is subject to it. It will specifically say if it's one of the vague laws, which could be applicable to federally regulated investment advisors and not just state advisors. And it will also indicate what you need to do if there's, under any adult protective services statute. So it's a very useful tool. You go click on it, it's free. We've gotten a lot of positive feedback from it, from, the industry, and also, from regulators. So, we're offering it up, so hopefully you can use it as a tool.
Yeah, and I'll just throw it out. I mean, I think this is fabulous. So I think on behalf of all of us, thank you so much for doing that. But, for those of you that are scratching your head saying, I don't know what to do for my annual review this year in terms of forensic testing, click on these states, look at where your clients are based, and see, are you prepared if we had a senior issue emerge? Would we know what to do? Does this work? How is it going to interact with our program? One question, and then we'll move on to Ron.
Are these reporting requirements based on the state of residence of the client?
Yes.
Yeah. The client.
Client.
And that's what makes us so complex.
Yep.
The more folks you service and where they're located, the more
Yeah,
complicated it
that's why when
becomes.
we looked at the issue and we decided to make this sort of part of our current practice, because our clients are having issues with it, we immediately knew we had to do a 50-state map, because, mid-size, even small IAs, and certainly the big boy IAs, they have clients all over the country, and it's very difficult to know what the law is. And so this is a great tool for you, because you could one day have a client from Alaska, one day have a client from New York, and you just click and it tells you what it is.
So I'm going to hold questions because we have to move on. We have to. I'm sorry, and I will come back at the end. With regard, go ahead.
Take the question.
Okay.
Yeah,
You have a comment?
You got 7 seconds.
Capacity issue only to be reported if the person is 62 or older, because obviously Alzheimer's, dementia can affect someone under 60.
Wrong. Most of these state laws are older adults or vulnerable adults over 18 and under whatever your age is, 62, 65, 60. And which is a nice segue to where I'm going to go, because both Carrie and Mavis have scared the bejesus out of you. I'm not going to answer this question, but you heard Mavis say earlier, you're fiduciary, and this is a nice 50-state map, but under Mavis's theory of the world, does a fiduciary have a mandatory reporting obligation regardless of what the underlying state says? You're a fiduciary. Why wouldn't you be a mandatory reporter? So, tell you what we've done at Wells Fargo Advisors. Skip all the slides. I'm going to just do some quick notes. We started in just knowing all of these variations. We didn't know Mavis thought the way she did. But anyway, all of these variations on the theme, the various states, we decided, one, we're going to choose the age 60 and older. Sorry for most of you that are like me. 60 and older is what we call a senior at Wells Fargo Advisors. All 50 states, DC, Guam, whatever. 60 and older. Then we skipped all of that. Are you mandatory reporter? We consider ourselves a mandatory reporter in all 50 states, Guam, Puerto Rico, whatever. Consider ourselves mandatory. We're not in all of those states. That is the way we view it. A little simpler there. We decided to, who do you train? No, everybody gets a training. Everybody gets a training. Every year. Everybody gets the training every year. So we just take some of these things off the table. Granted, we're big, huge, and whatever, but particularly, I keep looking at Mavis, but you heard her, I didn't say it, she said it. I think you're gonna have to make a.
They're my views, not those of the commission,
these are-
commissioners, or my
These are
colleagues
my
on the
views and
staff.
not Wells Fargo, so get that clear too. But only today, literally in this last 35 minutes, have I decided that one thing you might have to do is adopt what you think fits for you, but maybe you go just a bit beyond, because nothing's written from the SEC. They haven't given maybe you got to make your own guidance. This is BYOB, bring your own rules. I guess that's an R, but anyway, you got to decide, make these decisions. We went with a centralized team at Wells Fargo, so I'm in St. Louis. The whole team that focuses on the elder and vulnerable clients all sit there. So I'm not trying to have a manager in Utah figure out what all the nuances are. All the calls from all 50 states, Guam and wherever, they all come into St. Louis, and then that team, for them, it's not their first rodeo. They know a little bit more. And what we drive home in the training is what Mavis hinted at. You escalate. Do not do this on your own. Do not think you can understand this. And our numbers show the more we train, the more they realize, because before the last few years, they were doing this on their own. A couple of them being pretty good, but you know and I know, a couple of them making some horrible, horrible decisions on trying to do it on their own at the wrong time, and less worried about the firm, whatever happens to a firm happens, but clients getting bad service, bad outcomes because somebody decided to try to do it on their own. So I think, and I won't go much further than that, if you could come up with and get it in policies, map what you do to what your policies say. You got to do that for Mavis too. But you got to do all of this. You say it, you do it, and you do it again next year. You should be mostly okay, whether it's a state regulator coming in, whether it's FCC, that's about it. I want to
Yeah,
stop there.
and I actually agree with you, Ron. If somebody called me from, and said we have somebody who's being exploited, and it was in a state where it was permissive for them to report, my advice would be report it, especially if you're an IA and have a fiduciary duty. So I agree with that blanket approach, and it also just makes your life easier if it's that way too, from a process perspective.
And just one last anecdote, which is a true one for us. We literally had a scheme, an elder abuse scheme, uncovered by the mailroom because the mail was misdelivered. One of the policies, they open and look at it. And you can see this poor guy is caught up in some, if you send us this, we'll be sending you that back. So we're able to stop this scam in its tracks because the mailroom guy went through the training and understood this doesn't look right. So I think it makes a difference.
Yeah, and just one, let me throw one thing in, I
I'm
was just
finished.
thinking, no,
It's all
it's okay,
right.
sorry. One thing I just wanted to throw out there before I forget, which is we're gonna talk a lot about spotting, financial exploitation being perpetrated by third parties. But I know at this conference, there's a lot of compliance people. It doesn't happen all that often, but it does happen. Obviously, you need to keep an eye on what your employees are doing as well. I saw a situation one time where a financial advisor made friends with an elder lady. She had no family. His brother ended up moving in her house rent-free. They moved her into a subpar nursing home. The particular firm reported it, and in that instance, Adult Protective Services did come in and actually take action and bar the individual. The firm fired the FA. So just keep in mind that financial exploitation can happen both by third parties, but it can also happen by some of your employees, some of your advisors.
Fantastic. And I just want to walk through so that you know that we did talk about this, okay? The slides really were about NASA, which is state rules, FINRA and the trusted contact, what their requirements are and how that's interlaced with broker-dealer custodial requirements, talking about Senior Safe Act again and different federal policies. And so, Ron gave a great synopsis of best practices for you to consider at your firm. So use that as a checklist. And I can tell you we're going to talk about a lot of these during the case study. So without further ado, okay, some of these issues we talked about, before we jump in, I want you to see these were the actual questions that were being asked okay, when the SEC was going through and exploring during its examinations, you know, what are you doing with regards to protecting senior investors? And first of all, they wanted data analytics because that's so important. And they wanted to know what percentage of your clients are over age 62. What are the regulatory assets under management for those individuals? What do your policies and procedures, are in place for establishing trusted points of contact? Okay, so everything Mavis was talking about. And then looking at the full cycle of the client, okay? What steps are you taking upon death of the client with regards to handling of the account, handling client requests for changes to beneficiaries, powers of attorney, trustees, your frequency of communications with clients. And if you really think about this is all about servicing, regardless if this is death and incapacity and financial exploitation. This is really going down to a granular level of what are we doing, looking at the clients and making sure we're all on the same page in terms of internal controls, communications, supervision, et cetera. And this is where we're going to bring it full circle, okay? Here's the case study, and I'm going to randomly pick on people to issue spot, okay? Chuck receives his first round of document production and sees that Exposed, which is the name of the financial advisory firm, has a number of senior clients, i.e. those who are over age 62. In reading over one of the CRM notes, he sees that one particular client, Ann Vulnerable, attended the last 3 client meetings with her new boyfriend, Dollar Bill. Chuck notices that Ann has been slowly withdrawing monies out of her account in increasing intervals. And in fact, the last withdrawal represented 25% of her assets. Chuck reaches out to Wendy, who serves as Ann's financial advisor, to gather more information. During that conversation, Chuck learns that Ann appeared not to be herself at the last meeting. She was disheveled and seemed confused, and she had forgotten that she had withdrawn $10,000 the previous month. When Wendy pressed her for why she needed this latest withdrawal request, Ann stated, "I wanted to get Dollar Bill a nice gift. You know, dear, he's only 38 years old and he still loves his toys." So the first question is, what issues do you spot? Okay, anybody? Leave it open for him for now.
Elder abuse.
Is this elder abuse? Okay, is it Ann's fault that she happened to fall in love with someone 42 years younger? Maybe, maybe not. But boy, you start adding up all these circumstances, withdrawal of money, he's always in the meetings, everything else. It's starting to look suspicious. So typically, what would you do? You'd open an investigation, right? Let's find out what's going on.
Yep.
What else do we see?
Possible dementia with forgetfulness.
Right? Possible diminished capacity. And, you know, I'm also, you know, you start taking a look at it. We've got, you know, potential dementia, Dollar Bill's trying to influence her decisions perhaps. You know, somebody said, well, this sounds crazy. You know, of course, you know, I'd be notified by the custodian or something if there was this huge 25% of her assets withdrawn. Well, maybe, maybe not.
Well, you have to look at the pattern of money movement in general.
Maybe she was buying a real estate investment, right? Right.
Once you're suspicious, if you start to see an unusual pattern of money movement that was not the reasonable and customary approach that this client took for so many years, you already know something's not right.
And I'll tell you, I know that these folks have seen, you know, my co-panelists, situations where it's just like this. All of a sudden, spending and investment habits change everything else, and you really, you know, but they'll say, but this person needs it. I'm just trying to help, right? And then you question, what's my role as a fiduciary? How much am I getting involved in their life? But when you've had a client for 30-some years, you're like, this is family, right?
Somebody's going to ask, was Wendy a little slow to act?
Bingo. So the rep, okay, here's my question, okay? She's putting in notes in the CRM system. How many of you actually do training on what you should and should not put in CRM? That's me speaking as a lawyer. Okay, but more importantly, she didn't know what she didn't know. It looks like there was training that was lacking there, right? She should have escalated. She didn't escalate this to legal and compliance. And here's the million-dollar question. Who's Chuck? Is Chuck the CCO? If we put him in the role of CCO, this is more of a, boy, shame on me, maybe. What's my supervisory control for not catching this, right? But if Chuck, okay, And if you didn't realize the characters here, that was from the show Billions. So Chuck Rhodes, okay, if I put in that, okay, I'm sorry to say, FBI, SEC, you know, what if he's an SEC examiner? So my $1 million question here, not to, no pun on dollar bill, is, you know, if the SEC were here and you're the CCO, and all of a sudden you're in the middle of an exam and you just discover this, what are you going to do? You tell the SEC? I disagree with that. Go ahead.
Get your resume out.
Another question on this, though, and I actually have an example that came up literally in the last few days. So this is the extreme. This is where it gets to. The dementia, the change in habit, that happens early, and there's small signs over time. So you have a client who over the years would never give you a trusted individual, right? So you don't have one. And you are seeing signs now, but there's no exploitation. So there's nothing to report except, boy, we don't like this, that so-and-so keeps coming to his meetings by himself, his adult kids should be involved. Who can you go to when you don't have a trusted individual named? And how are you gonna have that conversation with the person themselves, you know? And so what do you do earlier than having to wait for there to be a situation to try to solve?
Yeah, and it's a good, I want to make sure we get back to this point, though. But go ahead, we'll address this and we'll go back to the
As-
question that was posed.
In order to protect yourself from risk as a firm, document, document, document.
Yeah,
It-
yeah, but
Right. So
and I,
some of the things we saw is that you know the count wasn't in any way flagged for concern. I mean, not for halting transactions, but you know, flagged for if you see something unusual, you would get on it right away, sort of thing. You know, so first of all, how are you tracking concerns that you have with this account or this individual, if it's multiple accounts? So that's first of all. Second of all, if you have it as a firm policy that you must get certain things, then it stops being about the individual. Like we have a firm policy because of all these regulations that we need to get a trusted person. Then it's not the individual's fault. I learned that with my children. It's like I couldn't get my child to brush his teeth. I put a timer on. It's not me telling you, it's the timer. You get it done before this timer goes. It's the same thing. It's somebody else's fault. It's not your fault for asking him for the diminished capacity trusted person, or trusted person regardless of diminished capacity. So I mean, it's all in how you approach it sometimes that it gets at the addressing your concern. You don't want to be put in this awkward situation. Why are you in this awkward position? Because you have some concerns and this wasn't.
okay, hold on. There's a lot of questions. We've got
I'm gonna do
two
one more.
comments, and yeah, go ahead.
Just one more. With that situation, if you're in Missouri, Missouri says you can reach out to someone reasonably related to the person. If they didn't put, and this is my gripe with a couple of the states that don't have the provision that's similar to Missouri, if they didn't have the foresight to give you the trusted contact or decide not to give you permission, you are stuck unless you're in Missouri or states like that where you can then call that kid. But you're hitting a point, a lot of us are single and never married, never kid, no relatives, so you still have that situation. We are still then reaching out to the state. It's going to be documented that I called Adult Protective Services. This is a vulnerable adult. You get out there, you do a wellness check to make sure these people are still all there. They may not go in some states, I won't name the state. They may go and come out there and say, well, she knew her name and knew where she lived. There's nothing more for us to do. But at least you've done your part. And then it's at that point that the firm has to make this go, no-go decision. Is this a person we feel comfortable, who we do know is, in our mind, is on a decline? Is this someone we will still work with? And one more thing we've done is we ask, and many of the clients say, Miriam, I've noticed some things different about you. Have you noticed it? We've had clients say, yeah, well, would you go talk to your doctor, check in, and we've had the diagnosis come about with them in that way.
Yeah, and I'm going to share that I take a slightly, perhaps, different approach, and that is you're a fiduciary. And these folks, a lot of times, are your family, okay? And they might not have family, but the advisor. And so I agree with everything that the panel said with one additional thought, okay? A lot of the advisors that we service have relationships where they actually say, even though we're not going to share account information per se, we're going to have family meetings. We're going to bring the family in. And to the extent that the client does have family or friend, you could always say, I wanted to make you aware, not talking about the account, not talking about investments, not talking about assets. We want to just make sure Sally's okay because she doesn't seem to be herself. Sometimes that's enough to spark some action, but you have to just say, want to make sure everything's good. You know, it's at least something, but what the other thing you have to think about from a legal perspective is what's in your advisory agreement, okay? And so the IAA model agreement, actually, when we talk about that language and how you can protect yourself, I want you to think about what does your contract say you folks will do in the case of incapacity, okay, and you know, where you're suffering from diminished capacity, or financial exploitation, or even upon death. What will the client expect to hear from you? And so I really strongly encourage, you know, take a look at the contract and the language that they have, and it says, look, if there's a significant life event, we will reach out to your emergency contact, okay, or your trusted contact, and this is what we'll have. I also want you to think about, and not saying that you should, okay, I'd have a candid conversation with the client when they're younger, okay? You know, if anything happens, the reason we're trying to get this information, or a person, is just to make sure you're okay. We're taking our fiduciary duty very, you know, sincerely and very special to you. You know, do you want us to do that? They definitively say no, document in your CRM, and you've done everything you can.
Yeah, and 65 under the federal, you know, Senior Safe Act is obviously kind of an arbitrary number that they plucked out of the air. To your point, it often starts earlier than that. People are often showing signs of diminished capacity before 65. And so, you know, financial services firms who are subject to the privacy regulations, you know, then think, should I call Adult Protective Services and let them know? The answer to that is yes, you definitely can. There's interagency guidance issued in 2013. The banking regulators were part of it. The SEC was part of it. And they basically said if you're required to report something under state law or you detect a fraud, that you can go ahead and do that and not risk violating, you know, the privacy regs. So there is some protection even, you know, below the age 65. You just don't have the immunity, but based on the guidance, you know, if you do it properly, your regulator's not going to say you violated the privacy regs.
And that's where the contract comes in, because it goes to protecting the firm, setting expectations. It's in the four corners of the document. Yes, ma'am.
So you mentioned about having it in your agreement of what you would do. The question becomes, though, if you have clients that signed an agreement 10 years ago when this wasn't as hot a topic, that's not the agreement they signed that said that you were going to do that. So the question becomes, is informing them enough that this is now written into agreements and that you're applying it to all your clients? Are you expected to get everyone to sign a new agreement?
Yeah, it depends if you have negative consent, positive consent, what have you. Positive consent, you have to get them to re-sign and repaper. Negative consent, you can provide them notification with basically, you know, here's your 30-day notice. If you look at these provisions, they'll automatically be adopted unless we hear from you otherwise.
Yeah, I always advise affirmative, do a supplement to the prior agreement and tell them, you know, this is a supplement we're having all clients execute. And, you know, obviously negative consent is great, it's easier, but sometimes affirmative consent can help you even more in the event of regulatory or litigation risk.
Until they don't respond.
Correct. Yes, sir.
So I guess following on what you said about fiduciary duty, how much can you really hang your hat on fiduciary duty? So if you have in front of you, say, someone of diminished capacity, and they want to do a certain thing with their money, and their family and friends and everybody around them are waving their arms and screaming, don't let them do this, is their investment advisor, and they're a person, they have, and you, let's say you failed to put these things in your contract before, to what extent can you, I mean, you could say grab the last thing in the bag, which is really fiduciary duty, and say,
Or terminate them.
I'm not going to do this.
Yeah, you can do that. It's kind of that Dirty Harry moment. Do you feel lucky?
Yeah.
No, I mean, those things happen.
Yeah, exactly.
Well, and here's the point. There comes a point in the business where this is a senior management. This is where escalation procedures are so important, because this is a senior management decision on what's our risk appetite on what we're willing to take. And that's face by case. We have got 28 seconds. I will have one question, only because you've already spoken. We'll talk to you afterwards. Yes, go ahead.
Is this scenario with dollar bill, right? If it's not the boyfriend, but it's the adult son, how does that change?
Happens all the time.
Yeah,
Don't
actually,
call him as the trusted contact.
Most exploitation is by family members and caretakers. So, you know, you need to be mindful when suddenly a family member is getting involved with the account, et cetera. The same analysis should apply. Under state law, under the mandatory APS laws, it doesn't matter if it's a family member or not. If they're exploiting the individual or you think they are, you need to report it.
And just final reminder and final comment, you know, remember your broker-dealer custodians have a requirement to notify them if they have a trusted contact. They will do those joint phone calls with you, and they have the ability to freeze the assets. So please keep that in mind. And with that, this panel will be available for questions afterward. Thank you so much for your attention and great questions.